Good afternoon, everybody. I'm Randy Zook, President of the Arkansas State Chamber of Commerce and Associated Industries of Arkansas. I'm delighted to welcome you this afternoon to what I think will be a very informative and helpful webinar presented by two distinguished attorneys from the Friday, Eldredge and Clark law firm here in Little Rock. Mike Moore and Katherine Campbell are experts in all the gory details of these very complex and tricky government programs, which have gone through such dramatic change in the last few weeks. So it's critical for all of you to get up-to-date, accurate information on just how to take advantage of these opportunities and put them to best use in your business. Mike Moore has served a long time as our chairman of our Unemployment Insurance Committee here at the Chamber. Kenny Hall, our Executive VP and Chief Lobbyist, works with Mike, and I am now pleased to turn this over. I have done my job. I'm pleased to turn it over to Mike and Katherine, and look forward to hearing all that they've got to show us and tell us about. Mike?
Thank you, Randy. Welcome, everybody. Katie and I are very happy to be here with you all this afternoon and try and walk through some of the many changes that have occurred. As Randy said, the last 3 weeks. 3 weeks ago, we were on the phone with the director of unemployment for the state, and she said that the whole unemployment system had changed in 72 hours, and that was long before the enactment of the CARES Act. So I believe we've had much more than an overhaul. It's overhauled 3 times more. So what we're going to do today is walk through the provisions of the CARES Act as they relate to unemployment, and then open the floor up to questions. And I know right now we have 284 people on here, and I think Tabitha has or is sending out to y'all in chat instructions to please ask questions in chat, and we will try to do our best to answer all of them. We already have about 30 questions that people sent in before this afternoon, and we'll try and answer those first. Our idea is that within reason, we'll keep going until the questions end. And I don't know how long that'll be, but we'll be here to do our best to answer your questions. So I want to thank the Chamber for allowing us to do this for them. Thank the Chamber for allowing me to be involved in the unemployment committee the last 6 or 7 years and learning more about it than I ever thought I wanted to. As Kenny and I say all the time, we're getting into head spinning territory pretty quickly, and we'll try and keep it to the brief facts, and then get into questions as we go along. So the CARES Act is HR 748, and the president signed it on March 27th, which was about 10 days ago. That the provisions of that act change or add to the current unemployment system in very, very significant ways. So the CARES Act stands for Coronavirus Aid and Relief and Economic Security Act. It provides 3 different new forms of unemployment assistance: PUA, which is Pandemic Unemployment Assistance; PUEC, which is Pandemic Unemployment Emergency Compensation; and FPUC, which is Federal Pandemic Unemployment Compensation. And all different ways to say unemployed people get a good bit more money than they're used to. So we'll try and go. I'm gonna close my chat off because I see questions coming through, and we'll look at those at the end. Thank y'all for getting started with your questions. So the PUA, the first portion of the CARES Act, which is Section 2102, is designed to provide unemployment assistance to individuals who are not currently eligible for unemployment for a number of reasons. It could be that they are, my example always is a hairdresser who rents a chair in a salon and has never had unemployment taxes paid on their behalf. It also applies to people who have not enough employment history, earnings history to hit the minimum quarterly earnings to allow them to participate, and those involved in the gig economy, which keep that part of the economy continues to grow. Those benefits are also extended to many people we'll talk about in a minute who may be unemployed and under circumstances that would not cause them to be entitled to regular benefits. This also allows people who are otherwise disqualified from benefits to participate under the PUA program, including those who were disqualified from their last work for misconduct in connection with the work. The PUA is available backdated to January 27th, going through the end of the year and up to 39 weeks of unemployment compensation. Remember, this is for people who are not otherwise entitled to regular UI benefits under the existing state program, as we have all seen. PEUC is a program designed to provide an extra 13-week of benefits to those people who exhaust their regular state unemployment compensation. The FPUC provides an extra $600 to anybody drawing any type of unemployment compensation. State unemployment, PUC unemployment, PUA unemployment, partial unemployment. Anybody who's receiving any unemployment benefits has the chance to get $600 a week in addition to that. And we'll discuss what that kind of means a little bit more down the line. So as I said, that's on top of weekly unemployment benefits. And you must be eligible for either regular unemployment or PUA. But since PUA is for anybody who's not entitled to regular unemployment, it covers everybody. Part of the act, the FPUC part, is that as you remember, the governor first announced it, and then the first of the coronavirus acts provided for the waiver of the first week of unemployment, and this provides that that 1 week waiting period is eliminated, and the federal government is paying for that full week, that first week of unemployment. It also provides, the CARES Act also provides financing for existing short-term compensation programs, the shared work program, which is what Katie is going to discuss in a few minutes. And we want to really emphasize that shared work program to y'all, because that is something that the unemployment people for the state really want businesses to take advantage of. So all of these different CARES Act programs are 100% federally funded, which is good news. As most of y'all know who have kept up with it, our trust fund, which was way in the negative after the last recession, has gotten built up through your efforts to over $850 million. And that if the federal money wasn't there, it would not take long for it to go away. And those of you who went through the last recession know what the increase in your unemployment taxes were at that time. And so if the federal funding keeps in effect, then we won't reduce that trust fund, and it will likely not affect either your experience rating or the unemployment trust fund. For those of you who are nonprofit or reimbursing employers, there's the Family First Act provided for, or the first part of the CARES Act provided for flexibility to states in how they get that reimbursement and assess penalties and interest. The CARES Act also provides 50% reimbursement to the state from the feds to cover those benefits out that are paid out on behalf of reimbursing employers. So coverage and eligibility under the PUA, you have to be able to work, available to work, unemployed or partially unemployed, or unable to work for a covered reason. And for PUA, you don't have to establish you're looking for work. All right, so if you are unable to work, and the operative word here is self-certifying. I want to step back for a second and discuss what that means. What I believe it means is that somebody who fills out their form and identifies a reason under the CARES Act for their unemployment will automatically be granted benefits, subject to the ability of their last employer to dispute that. It is likely to cause a lot of confusion, a lot of extra work on the back end, where you as an employer then have to disagree with somebody's claim. The good news is that if an employee gets unemployment under PUA, it is fully funded by the federal government, and it will not adversely affect your experience rating. So there won't be as great an incentive to contest it. So if somebody's diagnosed with COVID or has somebody in their family who is, and they have to stay away from work because of that, if they have primary caregiving responsibility for a child, unable to attend school or daycare, and what we may talk about in a little while is the overlap between this provision and the provision of the Family First Act requiring paid leave at 2/3 salary for somebody in that position. This is in the situation where somebody either works for an employer over 500 or maybe for an employer under 50 and is not covered by that provision. It also allows them potentially to make a claim for partial unemployment, even though they're getting 2/3 of their salary as emergency family medical leave. If somebody is unable to get to work because of a quarantine of themselves, or because a health provider has told them to self-quarantine, or if they're scheduled to commence a job and are unable to reach it because of the public health emergency. If the individual becomes the breadwinner because of somebody who dies as a result of COVID, the close of a business, and that the individual quit as a direct result of COVID-19, I think that is that one there is gonna cause a lot of y'all heartaches, because when employees figure this out, they can come in and say, I'm scared that I'm gonna get the coronavirus at work and I'm gonna quit. And the reason they do that is because they know they can get their unemployment plus $600 a week. Excuse me. What I've been advising my clients is to engage that individual in the process where you offer or inquire as to giving them some accommodation to either work remotely or to have some other circumstance which would alleviate their fear, so that if you need to down the road, you can claim that they quit without good cause because they did not take an opportunity to protect their job rights. There's also the employee retention tax credit to private employers and nonprofits, providing a payroll tax credit of 50% of the wages paid by you to your employees. You can do it if you partially or fully suspend pursuant to a shutdown order, or your gross receipts decline by more than 50%. If you're getting a PPP loan, you cannot take advantage of this tax credit. You also can delay your payroll tax and defer it over the next 2 years. Again, you cannot do that if you take advantage of the PPP loan. All right, so the next 3 slides are from the state and ways to apply for unemployment benefits. I know that from the questions we've gotten before, everybody's interested on the most efficient way to apply. There's online applications. Then the next slide says you can apply by phone. And finally, you can apply by paper and in the mail. So we may get to this in a little while, but I wanted to tell you, I watched the governor's press conference an hour ago, and Mike Preston said that for people who are applying under PUA, they need to wait 3 weeks because it's going to take the state that long to get the system up and running in order to process these applications, because they have to come up with a completely new application for benefit to put in place. I know they're working, burning the candle at both ends trying to do that. And but what I keep telling people is, if you're applying for PUA benefits, which are strictly COVID related, and you're not entitled to benefits otherwise, wait. Now, those claims are going to get backdated back to January, but the $600 per week is not backdated, but to March 27th, the date of the sign of the act. So if you have people, or you know people who have filed claims and they've been denied, they just got to wait and redo it. All right, so a lot of the questions that I've been getting are related to part-time unemployment, and without getting too much in the weeds into what Kenny and I talk about as head spinning territory. Anybody whose hours have been reduced are eligible to claim unemployment benefits and receive some benefits for their loss of income. When somebody who is drawing partial unemployment have to report their earnings each week when they file their unemployment claims. And for those of you who listened to Mike Preston earlier, he reminded people, because a lot of people are making unemployment claims for the first time in their life. They have to check in once a week with unemployment, and partial unemployment have to report their previous week's earnings in order to continue their eligibility. They can earn up to, and this should be, I'm sorry, I didn't made a misprint on this, 140% of their weekly benefit amount without loss of the benefit amount. After that, there's a dollar for dollar reduction. And that is why they have to, somebody on partial unemployment has to report their earnings each week, because their unemployment benefit will be different from week to week, assuming they're not either at the minimum or the maximum, which is $451 a week. All right, so the chart here is something from the DWS website, which shows if you have a weekly benefit of $250, how much you can earn before you begin to lose those benefits. And the weekly benefit amount is subject to the minimum and maximum. The weekly benefit amount is approximately 2/3 of your earnings. At least that's a good rule of thumb. And so I'm gonna turn it over to Katie now, so she can discuss the shared work program, and then we'll open it up to questions.
Thanks, Mike. Good afternoon, everybody. So I'm going to talk a little bit about the shared work program, and we have found this to be a creative solution for some of our clients for the issues going on right now, so I think it's worthy of discussion. So the shared work program is a program administered by the Division of Workforce Services. And the way it works is it allows an employer to reduce an employee's hours between 10% and 40%. And the employee is paid a portion of wages by the employer, and the other part, based on the reduced hours, would be paid through unemployment benefits. So as an example, if a person normally worked a 40-hour work week, a 40% reduction would mean that they're working 24 hours. So they would be paid by their employer for 24 hours of work and would receive unemployment benefits for the remaining amount, or for the part that they had not worked. And employees can receive up to 25 weeks of benefits under this program. And we found this program to be particularly beneficial during the COVID-19 pandemic because it is fully funded by the CARES Act, and it's really being pushed at the federal level. So employers' experience ratings are not affected because the CARES Act provides the full funding. In addition, so employees are making their wages, getting some amount of UI benefits, and they would also get the extra $600 per week. So it works to the advantage of both employees and employers. Time to continue to the next slide. So here we list the requirements for the program. So an employee's hours must be reduced between 10% and 40%. So you can't go under or over that. That's the window. The employees must otherwise be eligible to receive unemployment benefits. They must be able and available to work the reduced hours. And importantly, kind of for what's going on now, the employer must not have laid off more than 10% of employees in the group within the last 4 months. So they can have reduced hours for the employees within the program, but they can't have furloughed them or laid them off at this point. The employer also must certify that absent the program going into effect, the employer would have to have laid off at least 10% of employees in the affected group. And I guess backing up quickly to explain the affected group, basically you can use this program for some of your employees, not others. They just call the affected group the employees that you want to participate in the program. So we have clients who are using the program for, let's say, non-essential workers who they want to scale back, but they're keeping their essential folks on full time. You can also use it for employees at one location, but not another. If you have one plant that's operating, at full capacity, another one that's not. So that's just something to consider. So turning to the mechanics of how you get a shared work program in place, you do have to apply with DWS. So you submit an application, And it's a pretty straightforward application. You include the list of proposed employees' names and their social security numbers, their normal weekly hours, and the proposed percent reduction for each of those employees. And then you include an estimate of the number of layoffs that would have occurred absent the participation in the program. It takes DWS, we're seeing, about a week to approve the shared work application. It says it can take up to 30 days. And I'll tell you, I've talked to the gentleman at DWS who works on this program, and I know that he's extremely busy right now. He said he had 30 or 40 on his desk just today. So, there could be increased wait times based on the program, but right now it's seeming to take about a week, and I know that they are prioritizing these applications and doing the best that they can. Once you're approved, then the employees would submit individual applications for unemployment benefits, and this looks very similar to what you would do if you were individually applying for unemployment. And then finally, employees must submit weekly paperwork certifying the hours worked, gross earnings, absences, and that kind of thing, just so that DWS can do their job, making sure that they're paying out the correct percentage of benefits every week. And you can participate in this program for as long as for up to the 26 weeks, and quit really within a week's notice to DWS, basically by just not submitting that weekly paperwork. So if you sign up for the program, you're not committed for the long term. And then finally, just some considerations for the program that we have questions basically that we've encountered with clients who are considering the program or who have already signed up for the program. So the first thing is how the program works for companies who have received PPP loans. It's a little bit of a tricky situation because under, PPP is the payroll protection program that was authorized under the CARES Act as well, and it allows small businesses to receive loans about 2.5 times their average monthly payroll, with the expectation that a portion or all of it will be forgiven if used for payroll. So under the PPP, you must use 75% of the loan on payroll in order to receive full forgiveness. And you also must bring everyone back on by June 30th to receive full forgiveness. So the way that those two requirements of the PPP program kind of work with shared work can be a little tricky. But what we have been recommending and working with folks to do is, I think if you implement the program now, that you can take advantage of the program before that June 30th date. So you could scale back, a smaller group of folks, perhaps, or depending on the kind of the loan forgiveness, but taking advantage of the work-share program before the June 30th date in order to meet the 75% threshold that the SBA has put on these PPP loans. Like I said, you could use the work-share program for a smaller group of employees and increase the pay of other employees to make up the difference as an incentive for them, sticking with you through the pandemic. Or kind of think creatively about that. In addition, the PPP loans, they don't penalize borrowers if they don't reduce hours by more than 25% or reduce pay by more than 25%. So I think you could also set up a program to where you are using the shared work program for, say, 20%, cutting back 20% of hours, and that could work as well. So, and then I would also say that I know a lot of folks are accepting that the loan is still going to be very helpful for them, even if they don't receive 100% forgiveness. So, I think that you could, still use the work-share program to help you and your employees, understanding that you might not receive 100% forgiveness, but, the loan has a 1% rate after the forgiveness period. So it's still very friendly and advantageous for companies. So just, something to think about and consider as you are, thinking about implementing the program. Another question that we've gotten a lot is, does the work-share program apply to exempt employees? And it can apply to both non-exempt and exempt. The way that the program works, it's based on a 40-hour work week. So you would key, your hourly reductions based off that. As a practical matter, I don't think many exempt employees are going to see a difference in benefits, even though if it's keyed off a 40-hour work week, because, the amount of unemployment benefits that you get would not, be 100%, I guess, for that for their work lost. So I think as a practical matter, it would probably be about the same anyways. But a point of caution here is if you reduce the pay of an exempt employee below the threshold of $684 a week, they would no longer be exempt. So then you would just want to be thinking about kind of the Fair Labor Standards Act implications of that. So it's probably the overtime implications it's probably a moot point because you're reducing hours. So you probably wouldn't get to 40 hours in a work week anyways. But the FLSA has record keeping requirements. You would want to make sure that you are following all of that. And as I mentioned earlier, you do have to provide weekly timesheets to DWS anyways for the program. So you would probably be tracking hours in any event. So just a few things to consider, but you could make the program work for exempt employees. The next question is, what if I choose to lay off employees after I create a shared work program? This creates a little bit more of a problem. So you can't remove or lay off more than 20% of the people in your affected group. So once you kind of set the number of employees that you want to participate in the group, that needs to be pretty close to the working group for the remainder of the program, or else you will be disqualified from the program and probably can't propose another group for some time. And then kind of relatedly, if your employee doesn't want to work the 60% of hours or whatever percentage of hours you propose, DWS takes that pretty seriously. They consider that refusing to work, and they'll disqualify the person from benefits, not just from the shared work program, but from unemployment benefits more generally. So we are telling folks that you really want to have an upfront conversation, with your employees and, kind of your staff, thinking through who would want to participate in the program and who makes the most sense to participate in the program, to make sure, before you apply that both you and the employees are willing to kind of stick with it throughout the implementation of the program. So that's just kind of some information about the shared work program, and I think we'll probably get into more of the questions, but gives you a sense of what it is designed to do.
All right, so let me add just a couple of things to what Katie was saying there at the end, and then we'll get to the questions. As I said earlier, the state really likes the shared work program, and one great benefit for both the state and indirectly, or maybe more directly y'all, is that the feds pay all of the work share benefits, the partial unemployment benefits that are paid out, whereas if you just laid people off, they would be entitled to regular unemployment benefits, not under PUA, and that would come out of the trust fund and thus adversely affect businesses' unemployment taxes down the road. The other reason to do a shared work program rather than laying some people off is that you keep them close and not where you have to call them back to work, because there's going to be some difficulty calling somebody back to work who's making more money unemployed than they would be once you recall them. And so I know we got a million questions. They keep coming in. What I'd like to do is I'll read the questions that we got before the session started, and Katie and I can kind of take turns answering them. Kenny Hall with the chamber is here and can jump in anytime he'd like, and then we'll move to and try and work through the questions that have come through in chat that we don't think we've answered. So the first question is, we have 3 employees and we plan to furlough 1 completely and cut 2 down to half-time at 20 hours a week. For the half-time, will they be able to draw unemployment or the 600 enhancement, or is this a shared work instance? That is, for everybody in that situation, they would be entitled to draw either full or part of unemployment plus the $600 a week each, and that's not a shared work circumstance. The next one is after paying an employee 2 weeks for being quarantined and they aren't positive for the coronavirus, are you required to pay additional sick time for other illness that occurs after the initial quarantine time is over? Katie, I'll let you, if you're unmuted.
Yeah, so the 2 week, I think here is referencing the 2 week paid sick leave under the Families First Coronavirus Response Act. And, you know, after that, you know, no additional paid sick leave is required.
The next question is, can you speak to how, if a partial unemployment filer being eligible for the enhanced benefits? I think we've covered that. Partial unemployment gets $600 a week extra. We've answered about non-exempt workers. If someone is suspected sick or is sick that falls within the CDC guidelines, the employee is sent home on unpaid excused sick time for 7 days. As long as they're not symptomatic, been fever-free for the last 3, they can return. Is Arkansas UI covering this? My response would be that is a PUA claim that the employee can apply for and get benefits, and it won't hurt their future unemployment claims. It's just that the 1 week is waived. Next question is, many of our people have tried the last 2-3 weeks to apply online, and they had to go and reapply. Does the website not work? So I think, Katie, what have you heard lately of people who have gone in to apply?
I've heard that there has been, you know, a week plus, I guess, kind of backlog in terms of getting through by phone or online, but we've been assured that, you know, you will start receiving your state benefits the day that, you know, starting the day that, you know, you were laid off. It might just take some time to get through, you know, to DWS to get that application in, but, you know, they are just encouraging people to, you know, to kind of keep at it and to be patient, because they obviously have a lot of people, you know, trying to get through.
Okay, the next question is, if there's a mass shutdown or layoff and the unemployment office has been officially warned, can the business assist the employees in applying, and or can the employees turn their paperwork in early if the online version doesn't work? I think what I would say now is the online application system is probably working a lot better. Employees can file their claims in advance of when they're expected to be laid off, but that's not going to help them get them any earlier. Next question that hadn't been answered. One question is, what qualifies and when for the 600? I think we've answered that. Is anybody in March 27th? Am I right there, Katie? March 27th?
Yeah, that's right.
All right, so the next question, if we do a layoff on April 15th, employee files the next day. This question I saw earlier, that there were some people saying that states might be reducing their usual unemployment benefits to offset the 600, and that is specifically prohibited in at least 3 places in the CARES Act. The feds aren't going to give their money away and then let the states benefit from it. One of the things that I think will come from this is that the feds in their oversight will make sure that the state is not classifying a claim as a PUA claim when it ought to be classified as a regular UI claim. because that's the difference. That's the only difference in all of this that determines which pot of money it comes out of. All right, so we have an employee who is a single mother of 3 and is struggling to get and pay for childcare. We consider giving her a leave of absence to stay home with her kids. If she could get unemployment benefits, would she be able to get them? Would she get them if she resigned? Katie, you got any ideas on that one?
Yeah, I think kind of going back to your discussion earlier, this would fall under the, unemployment benefits for purposes, people directly affected by COVID, and, the child care is listed in there. So, I think to the extent she is employed by somebody, by an employer that falls within the Families First Act, they want to visit the, the paid sick leave and the paid extended family medical leave first. But then could make up maybe so under the Families First Act, you get paid at 2/3 rate for child care, staying home with the child. So she could seek her extra third through PUA, or alternatively, if she worked for an employer who was not covered by Families First, then she would be able to get unemployment benefits, for the need to stay home, while that child care was unavailable.
Yeah, and so another issue this brings up is that under the Family First Act, if you're paying 2/3 pay for the emergency FMLA, you're not entitled to count that 2/3 pay as payroll for purposes of the loan forgiveness under the PPP to hit your 75% payroll. And so one of your strategies might be to pay 100% of the pay to somebody in that situation, which gives you a little bit of extra payroll cushion, and they would not be able to apply for unemployment. They just get their pay. A question, is there a minimum number of days required to work in Arkansas to be eligible for Arkansas unemployment? Yes, but not under PUA. That's for people who wouldn't be otherwise eligible. And I think a related question, a friend of mine has worked fewer than 6 months, and they would be like a sole proprietor, right, Katie?
That's right. Yeah. So basically, if you're not otherwise eligible because you haven't worked the minimum number of days, you would still be eligible for PUA in this instance.
I'm going through to see if what we've discussed so far answers these questions. There's a question from somebody about was being told by unemployment that there were no taxes paid under their Social Security number last year. I'm not sure of the facts, but what I would interpret from that question is that employee was employed by a reimbursing employer who does not pay unemployment taxes, but at the end of each year, the benefits charged to that account, or they have to pay back to unemployment. That is the part of the CARES Act where reimbursing employers will not suffer as big a hit as they otherwise would.
I'll just add to that, because I actually have just spoken to DWS about reimbursing employers, and they said that right now they are being a little bit flexible, and this could become more flexible, but they right now are not requiring reimbursing employers to pay anything in terms of reimbursement until March of 2021. So just for those who are trying to plan for that.
That's great news for nonprofits.
Yeah.
The 600 benefit lasts through July, correct?
Yes, that's right. July 30th.
Somebody asked, does the WARN Act still apply in this situation? The short answer to that is yes. There's a whole lot of longer answer, and I'll just say that for the WARN Act only applies if the loss of the job lasts 6 months. And so for what, fingers crossed, please God, let this be less than 6 months, it would not affect us. I keep waiting for the Department of Labor to issue some guidance that the WARN Act is suspended for the duration of the pandemic, but that hadn't happened yet. All right, so now we've got 40 million questions in chat. So I guess the best way, Katie, if you got your chat where you can open it, are you in it?
I do. Yeah.
Okay. So I think, why don't you start reading the questions, and we'll just kind of go down and see if we can answer
Okay.
them.
That sounds good. I'm gonna start at the top here.
The first one I see is at 3:07 p.m. about shared work plan.
That's right.
Yeah, okay.
So will UI benefits be available to those who have to take a pay cut due to COVID-19? I think we've already covered this, but the answer is yes. I mean, if you have a reduction in hours or pay, you can get part unemployment and then would be covered by the additional $600 weekly benefit through the end of July as well. Will workers on the shared work plan be eligible for the $600 weekly benefit? The answer to that is yes. And as Mike said, that it's particularly advantageous because the worker gets the extra $600 weekly benefit and it doesn't count against the employer's experience rating. So it's kind of a win-win for that.
The next one that I see is that some of our staff received deposits last night for benefits, and it was 390, not 600. I believe the reason for that is that the state did not actually sign the agreement with the feds until Saturday. And so it was not in effect for a week to do that. It's just going to take a little more time to do it.
Yeah.
My guess is that FS benefit is the regular weekly benefit they would be entitled to.
The next one says, my husband is a police officer and gets paid on 1099 for off-duty work. Would he be able to qualify for that? Yes, as a 1099 independent contractor, he would get the PUA for that.
Yeah, and so what they require then is for him to submit sufficient earnings information from that a weekly benefit amount can be assigned to it.
I think we've covered that next question. I guess the next one's at 313. What if someone who has exhausted their benefits and only been working for a few months and let go for COVID-19? Can they receive unemployment? I think we actually covered that, but they would not otherwise be eligible because they hadn't worked long enough. They would still be able to get the PUA, which would also include the extra $600 till into July.
And remember, the PUA can go up to 39 weeks. In Arkansas, if they're just getting regular unemployment, they're going to get 16, and then the FPUC benefits kick in for an extra 13 weeks, and it's likely that the state's extended benefits will be kicked in because of the levels of unemployment.
The next question, if someone qualifies for PUA, do they automatically qualify for state unemployment too? So the answer to that is no. If you apply for PUA, that means you weren't eligible for state unemployment, but you would still get the benefit through the federal funding.
Yeah, and the benefits under PUA would be the same amount they would get in regular UI benefits plus the 600. And I got one here that says, are public employers eligible for the tax credit? And I apologize, I don't have the answer to that one.
Yeah, I don't either.
Question for a truck driver who has work available. If they choose to quit because they're scared, are they eligible to draw this unemployment? For anybody who has work available, if they quit because they're scared, they've got a chance that when I think I discussed that earlier, I hope I did, that that's a situation where an employer should discuss what efforts they could take to make that easier or to make that employee less scared. The next one is somebody has 2 full-time jobs and one of them shut down. Can that person file for PUA? Yes. They're going to have partial unemployment because they've still got earnings.
And the next one's kind of long. We have employees in several different states and based on certain criteria have reported wages and paid unemployment tax to multiple states throughout a period of 5 quarters. For example, wages here in Arkansas for part of that 5-quarter look back in the state of Indiana. Currently paying into state of Indiana UI tax so that they have filed in that state for unemployment, but have some reported wages in Arkansas. Should an employee apply in both states to receive full state benefits, or will the states share wage information and just pay from one state?
This is head spinning category, but
yeah,
my understanding of the way this works is that an employee applies in one state and receives benefits in that state, usually as a resident, and that there is sharing between or among the affected states who have had taxes paid on behalf of that employee's wages. I hope that answered that question.
yeah.
I do know that people will sometimes apply for unemployment in a different state because of that state's benefit amount.
Okay, so the next one says, I have a family member that works for the Salvation Army and was told she does not qualify for unemployment benefits. Is that accurate? I would say certainly not in this era. I think if somebody was ineligible to apply, they would be able to now under the PUA. But my thought is that this might have originally been a religious exempt organization, right?
Yeah. I think this. There are some very narrow exemptions. For example, churches. But I believe that an employee of a church who would not otherwise be eligible for benefits is eligible for benefits under PUA. So the next question is, if a self-employed sole proprietor had to close the business due to COVID, would they be eligible to apply for UI? Yeah, they're eligible to apply for PUA.
So the next question says, can a sole proprietor who pays independent contractors be in a shared work program? I have to admit that I don't know the answer to this for sure, but my hunch is probably not, because it is based on kind of employees and having paid into the system over the the last 5 quarters. But Mike, do you agree with that?
Yeah, because the reason is that sole proprietor would not have paid any unemployment benefits in any unemployment tax into the system based upon the payments made to those independent contractors. Those independent contractors would be entitled to apply for unemployment benefits under PUA, where they would not otherwise be eligible for UI benefits because they hadn't had those wages paid in on the back.
Yeah, that makes sense. The shared work program is, a program that's been around for a while and wasn't just created in response to this. So be based
Yeah,
on
and
that.
and for those of you with multiple state operations, there are, I looked this morning, there are 28 states that have shared work plans program. Great question. What can employers do to help our employees get information needed to have their claim processed? Help them get onto the DWS work website and help them work through the claim process. It's not simple.
Yeah. I would also add that based on our conversations with DWS, they're having to input a lot of information in, by handwritten applications and things. And they said that, typos and missing, boxes that aren't filled in have really slowed things down. So I think to the extent you can just make sure they have all the information and that it's filled in legibly and properly, it will really help a lot.
The next question, a $17 an hour employee reduced to working 24 hours receives 408. Could they still draw partial unemployment and the 600? If they made over the threshold, would they still get the 600? It's my belief that if your weekly part-time earnings reduce your regular weekly benefit amount to 0, then you're not entitled to the 600, but that is not entirely clear right now. Next question, can you address the furlough option for a way to keep an employee active without laying them off? I hadn't heard the word furlough used in 15 years, and everybody seems to be using it now. My belief is that what most people mean by furlough is a temporary layoff. And what we are advising our clients to do, if you're laying somebody off, tell them it's temporary. A lot of the people have started to use the word furlough because it gets them away from the word layoff, which in most health insurance policies disqualifies somebody from participation. My understanding is that virtually all of the health insurance providers in Arkansas are waiving or relaxing those participation requirements and not requiring you to use the word furlough.
The next question, can an employer who has already laid off due to COVID prior to the CARES Act be eligible for the work share? I actually just talked to DWS about this week, and the answer is if you have just reduced hours or pay, then you can still do the work share program. If you have, laid off or temporarily laid off more than 10% of the group that you would be proposing for the program, you would be ineligible. But as I said earlier, you can kind of be creative as to how you make the group that participates in the work share program. So depending on your layoffs, you could still perhaps participate in the program, but just structure it around those who had already been laid off.
The next question is, I represent a 501c6 chamber organization. We can't take advantage of PPP. Seems like the shared work program would be a good solution for us. And I spoke with a chamber executive not 2 hours ago, and who is finalizing their application for the shared work program. And I think it's for a chamber, it is the perfect way to go. The next question, how does a self-employed person apply? And that is, I'll go back to what Mike Preston said, wait 3 weeks. And because that's a PUA application and they don't have that application ready yet.
Next question is the $600 paid out weekly on Tuesdays like state unemployment? I don't actually know the answer to that, Mike, do you?
I think that the feds give the states the option to make the payment separately or together. My guess is that that Arkansas is going to want to make them at the same time, maybe in the same check. But again, we're on it's not all going to happen at the same time. We've got a month-long process in here where things are going to start slowly getting in sync for the state.
And Mike, this is Kenny. You probably heard Mike Preston say today, the first batch of those checks went out last night.
Right. And so, but they hadn't processed half the applications that they've gotten. They gotten 110,000 unemployment applications and expect to have 150 by the end of the week. And he said they're calling in all sorts of people in his department who don't do unemployment to do unemployment for the next month or so.
The next question, is there a place where employers can see how much a furloughed employee is making per week in state benefits plus the $600? Mike, you may be able to speak to this a little bit better, but my understanding is that people usually make about 2/3 of their regular wage up to the limit of $451 a week. Then with the $600, plus $600 would be kind of a ballpark figure, but there's no way to know for sure. Is that right?
Yeah, you get employers get a quarterly report showing the benefits that have been paid out under their account. I don't know of any real-time kind of way to check that. But I would say to the person asking that question, if you wait a couple of weeks till things die down just a little bit, I bet if you call DWS, they can give you an answer to that question. But they are in my experience, the most responsive government agency I've ever dealt with. So we have, let's see, there's a reduction in pay without a reduction in hours, making an employee eligible for partial unemployment. Yes.
I think the next one is about the FMLA. So can you apply for the FMLA pay if your child's school is closed, but you're still able to work from home a little, or is there a requirement that you aren't able to work at all in order to qualify? I think this answer has just recently kind of been fleshed out in the regulations from DOL in the last week or so, but if you're able to work remotely, I believe that comes into play with the FMLA. Is that right, Mike?
Yeah. Now, that's going to be a fight between the employer and the employee as to how little the employer is willing to accept in order to avoid that 2/3 pay. The next one is, can the shared work program be canceled at any time?
The answer to that is yes, with basically a week's notice to them.
Yeah. Question, recommend a good resource to calculate what the total benefit would be for a 50% furlough employee. There's two charts that I think are within the DWS website, and one is DWS ARC-500.1, and one is DWS ARC 516, and those talk about benefits and partial benefits. And they were way too big to put on the slideshow because they're about 12 pages altogether. But they're a good way to look at what those benefits would be.
And the next question is, how much would an individual receive if they've already exhausted UI benefits? Under this one, they would be eligible for PUA, which, as Mike said, you would receive kind of the same level as your state benefits just through the PUA.
And the 600.
Right.
Under the shared work programs, the person received 2/3 of the lost hours, wages, or full amount. I think under the shared work program, if I work 75% of my regular hours, I get 75% of my regular pay.
Right.
Now, the reason that they have to report their hours weekly is that I think DWS knows that in those situations, there's probably going to be some difference in hours week to week. And I think, Katie, I thought I remembered you saying that they suggested that to make it, unless otherwise indicated, make the program at 40%, and then that might their weekly earnings might be more than that, and that would simply reduce their unemployment benefit.
That's right. Yeah, they recommend that you set it, unless you know for a fact that somebody's only going to, be at 90% hours the whole time. They said to set it at 40%, and then on a weekly basis, you can kind of, change that as needed. So, and they will just keep the reduction off the weekly timesheet. So.
Yeah, and again, if you got a PPP loan, you got to be careful about how you implement the shared work program so you don't miss out on the 75% payroll threshold for forgiveness.
Yeah, and I would add, we're still waiting for guidance from the SBA on the 75% payroll requirement as to whether if you say pay 65% on payroll, if it's going to be an all or nothing, you don't get any forgiveness, or you just get 10% forgiveness reduced. So I kind of think it'll be the latter, but we're not sure. So we expect something out hopefully this week on that. So I think that'll also inform the decision.
The next question, somebody who got benefits, but after the initial denial was reversed, then it's still on appeal, and the employee is currently not receiving benefits. I believe that employee is entitled to PUA.
Yeah. Can 100% owner of an S Corp business draw unemployment if they drew no salary in the past? And I think similarly that would be a PUA situation.
Right.
This one was from somebody who joined late, but they asked, when will the self-employed be able to receive those benefits? And Mike, you said 3 weeks or so, right?
Yeah. Mike Preston asked for 3 weeks time to get the process in place. Now, after that, the problem is going to be, it's going to take a little while to properly calculate the benefit amount. Hopefully, the guidance that they give to applicants will make the monetary determination, as they call it, easier for them. That's going to be in my mind the hardest task the state has, is that they just used to getting a wage statement, and now they're going to have to get a much more complicated set of earnings from a salon owner or otherwise somebody who's not been entitled before. Is there a guaranteed federal reimbursement for self-insured reimbursable employers? I think we covered that. The feds have seemed to guarantee at least 50% of that. And as Katie said, she found out today, or maybe it was Kenny, I don't remember who said it, that there's going to be some flexibility into next year, well into next year, for reimbursable employees to get up to speed.
What about somebody that you've offered a job to but cannot start them yet due to COVID? My understanding is that they're covered under PUA for that as well.
Question, if you're trying to put in your social security number and PIN number can't be entered, what does that mean to the family first? I'm not sure what that means, other than the fact that if this is trying to file an application for unemployment, wait a week and try again. If a person's been cut back from 5 to 2 days per week, can the employer require them to exhaust their sick days before filing for UI? I think that if the policy allows them to, yes.
In filing unemployment, it's my understanding you're required to show that you've actively been searching for a job. However, if we've laid off an employee temporarily and plan to bring her back, she's still required to show that she's looking for a job. That requirement has been waived for purposes of the pandemic period.
Yeah, under PUA, it has. Under FPUC, which is the extended 13 weeks, which is not necessary. That's just extended weeks, not COVID reasons. They have to be looking for work, although the guidance says they don't, the state should be flexible on that. You know, as probably most of y'all have experienced over the years, the requirement of actively looking for work is probably not quite as strict as it was some years back. Where they go online for PUA, that's going to be, as we said, three weeks from now through unemployment through DWS.
Can an employer require employees to take vacation time before filing for UI? As Mike said, if their policy requires it, then yeah. I guess one thing to kind of add here is I've had several clients looking to, I guess, kind of extend, severance type payments during this period to get people through, and those can affect the timing that you would be eligible for unemployment. So I guess just bear that in mind. People trying to be helpful can actually delay the onset of unemployment eligibility.
Yeah, exactly. If you put down in a response to an unemployment claim that you gave them 8 weeks of severance pay, then they're not going to get any unemployment benefits for 8 weeks, even if you paid it all at one time.
Right.
The PUA claim is exactly what the PUA claim, I believe, will be made on the same form as a regular unemployment once they get the forms ready. They want to have all the information necessary to decide it in one place. If I work a full-time job and a part-time job, my hours get cut on my full-time job, am I eligible for PUA? I think you're eligible for regular unemployment plus $600. Next one I have, if you're 50% furloughed and work 20 hours, does how much you earn affect any part of the remaining 20 hours you will claim on weekly UI? Yes. Again, you figure out what your weekly benefit amount will be, and then you multiply that benefit amount by 140%, and whatever that amount is, you can earn up to that and not affect your benefit. Everything you earn above that takes dollar for dollar away.
Can a church with a daycare and schools and janitorial workers apply for PPP? Also, are other ministry employees considered for PPP? The short answer is that probably yes. The SBA issued some guidance last weekend about this. It said that a religious organization or faith-based organization can apply for the PPP program as long as they kind of meet that 500 employee limit. So, and they're a 501c3.
But if the question is, can they apply for the PUA benefits? Yes.
Yeah.
Because they will, most of those would be otherwise unable to receive benefits under state law.
So if I work full-time, I will be going part-time, but draw on my Social Security, I'll still be able to receive the $600. My understanding is that the $600 is not based on, receipt of any other benefit, so they should be entitled to the $600.
Yeah, the question, there's all sorts of questions beyond the scope of what I could figure out right now as to how that might affect your Social Security benefit.
Yeah.
Because of the earnings limitations on that. All right, so here's a question we got on email. If a regular hourly person was laid off in December 19 and did not apply for unemployment because they were able to work projects but are unable to find those paying jobs now due to COVID, can they apply for UI, regular or PUA? And I believe that they would be entitled to regular unemployment, because when you are laid off, you don't have to file your unemployment claim immediately. And so if they were laid off for reasons that wouldn't disqualify them, they would be entitled to unemployment benefits based on those wages. And those would be regular, not PUA.
The next one, I've been furloughed by my company by 50%. So instead of being authorized to work 40 hours, I can only work 20 hours per week. I'm currently signed up for UI benefits and in the system. There seems to be some confusion on whether working that many hours will mean I receive no compensation from UI, even though employers were told their workers would. Hearing one explanation that we should work 40 hours one week and then 0 hours the second week. The flip side I'm hearing is if we work 20 one week and 20 the following week, we're paid biweekly. So I guess the question is basically, do you qualify for unemployment if you work 20 hours per week? And I think the answer is yes, you would qualify for part-time unemployment plus the $600 weekly benefit.
Yeah, and so you qualify for weekly benefits, and depending on what you make, because remember that the maximum weekly benefit amount is $451. So if you take 140% of that, that's what you can earn up to in a week without reducing that amount. So if you're I hadn't done the math, but if you're a $75,000 a year employee and you're cut into half, you're probably going to make too much on a 20-hour week. You're gonna take away all of your weekly benefit amount. Somebody asked about the 3 weeks to file for PUA, according to Mike Preston, and that's 3 weeks from today, is the way I understood him to say. Next question is that somebody got the Arkansas amount plus 390, and that might be partial payment for the week, and that's as good an explanation as I can think of as any, is that it wasn't a full week of unemployment after the president signed it.
Yeah, that makes sense to me. Next one says, if I understand correctly, a self-employed person is entitled to both the $600 weekly benefit and the state UI benefit. I think it would be that you would get your kind of the equivalent of the state UI benefit through the PUA plus the $600 weekly benefit. So
Yeah, so the max amount you can make is $1,051 a week on unemployment. And the fact of the matter is that there are going to be a whole lot of people on unemployment that make more on unemployment than they were making when they walked out the door.
I'm a self-employed cosmetologist and applied for unemployment on March 25th. I've received an email from DWS, but nothing confirming whether or not I'm approved. Are we waiting on the government to approve the pandemic assistance, or what can we expect to receive weekly? I think we've covered that. It'll take 3 weeks, but then you'll get the equivalent of your state benefit under the PUA plus 600.
And then there's a question, does this apply to employers over 500 or all? And it applies to all. Try and work through the ones that we hadn't answered already.
Yeah.
The question, if I'm not eligible for UI benefits because I made greater than the state weekly benefit amount, would I be eligible for benefits under the PUA? That's if I get enough more than my weekly benefit amount to cancel that out, would I be entitled to the 600? And I got to be honest, I don't know the answer to that question right now. I've seen nothing in the 3 different guidance letters that the DOL has sent out over the last week or so that even addresses that.
I think that might be all of them, unless you have more, Mike.
Somebody asked, would a terminated employee be eligible under the PUA? And it is my understanding that someone who has been disqualified for benefits because they were terminated for good cause connected with the work, for misconduct and connected with the work, would be eligible for benefits under this act. The statement I heard at one point in time was that somebody who had been disqualified for engaging in fraudulent claims would be entitled to benefits under the PUA. Which maybe wasn't what was intended, but may be the result.
I guess I just got another one pop up. I just need confirmation that the waiting week has been waived. The waiting week has been waived at this time and until further notice. So if a temporary layoff for lack of work because of reduction of volume due to COVID, employees would not have to have a waiting week. And that's correct. No waiting week right now.
Yeah.
Lingering questions here. Employees on a shared work program. Oh, sorry. Go ahead, Mike.
Yeah, eligible for both state and the 600. Yes, assuming that they get the benefit under the shared work program, they get the 600 too.
All right. It looks like the questions have stopped. Mike and Katie, thank you so very much. And thanks also to everybody that listened in. We are happy that we were able to provide this. And Mike, you're always at my side and appreciate that. Katie, I look forward to meeting you sometime.
Absolutely.
Good deal. Thank you all. It was a great hour and a half.